we're not going to sentence them in abstention, so let's give them a couple minutes. Allison will get them, I assume? Have it ready when you grab Jerry. You want to talk to us?
Hey, Jay?
Mr. Mossman? Yes, sir. All right, we are on the record in case number 682006, case caption the state of Ohio versus Scott Gardner. Mr. Gardner is present in court today along with his counsel, Ms. Allison Hibbard, and the state of Ohio is represented by multiple assistant prosecuting attorneys, but I think lead counsel in this case is Ms. Samantha Stoll. The record will reflect that we're here for purposes of sentencing today, inasmuch as Mr. Gardner entered a plea of guilty to a single fourth-degree felony count midway through a bench trial. I'll turn to the government first and ask for statements with regard to sentencing.
Thank you, Your Honor, and may it please this court. As you did just state, the defendant did plead guilty to one count of failure to remit sales tax, a felony of the fourth degree, in violation of Revised Code 5739.12 subsection A1. An additional condition to that plea agreement, and we will ask this court to put it in the sentencing entry today, is that the defendant agreed to pay restitution in the amount of $149,954.54, and that's to the State of Ohio Treasury Department. I am aware that this court sat diligently through the day and a half of testimony that we did make it through before Mr. Gardner entered his guilty plea. However, I do just want to go through a brief summary of the testimony that was presented. The defendant, he pled guilty to one count, as we've stated, a failure to remit. So with that, I am going to limit it to the testimony that had already been presented and to the sales tax portion of this case based on the plea that was provided. Your Honor, you did hear testimony, and then there were stipulations to the additional exhibits so that we didn't have to look at each monthly exhibit of the underreporting that the defendant did for his sales taxes, not just his gross sales, but also the sales tax that he was due to pay to the State of Ohio. You heard testimony that he was the owner and operator of a company called CPACS, or Constant Protective Security, that provided security services. They are subject to sales tax. He would invoice individuals for the payment of the services with the sales tax. He would take that in, and that money is supposed to go to the state of Ohio. We saw through the reporting that the numbers were grossly underreported. We're not talking about a missed decimal point. We're not talking about 100 instead of 1,000. We're not talking pennies and cents. Over the time period of this investigation, we were talking $203,362 and change. You heard about the investigation by Agent Joy Lieb, who, just for the record, is in the back, along with BCI forensic accountant Gregory Jeffries, who are heavily involved in the investigation of the case, that the defendant did cooperate. I'll agree with Ms. Hibbert from her sentencing memorandum. The defendant did cooperate to an extent with Ms. Agent Lieb during the investigation. And Agent Lieb, you heard, gave him the benefit of every doubt. The number originally, actually, Your Honor, was $255,000 and change. Every time the defendant came to her with a story that he wasn't charging sales tax, that he wasn't properly reporting his exempt sales, that someone else entered money into his QuickBooks, someone else entered his Ohio Business Gateway, she gave him the benefit of the doubt for each one. And that's why that statement, that central column, I'll say fourth from the right, says not in QuickBooks. We gave that benefit to him. He was not charged with that. But there's still $203,000 unaccounted for. As you heard, or as you know, it was count 3, and that alleged for the underreporting for the year of 2014. That's January 1st, 2014 to December 31st, 2014. And Your Honor, while we do recognize this is a felony of the 4th degree, under 292913 B1B, this court does have the ability to sentence the defendant to prison because he was under community control sanctions for not one, but 2 different cases relating to sales tax and Mr. Gardner's vendor's license, both out of Medina and out of Cuyahoga County. And I want to address those just briefly because I think it's important to show the defendant's intent in his actions in this case. Specifically, in Medina County, first, Your Honor, this was the subject of a false license and not filing sales tax for a cigar company that he owned with others out there. Around the same time, he gets indicted in Cuyahoga County. And that, again, is for sales tax. There's a large amount of money coming into his accounts that's discovered that doesn't match with his sales tax filings. And in the Cuyahoga County case number, he was placed on probation in this court in June 4th, 2014, and the Medina case, October 6th, 2014. And out of the Cuyahoga County case, he agreed to pay approximately $28,000 in back sales taxes for about 2 years to the Ohio Department of Tax and the Ohio Treasury, just like he did here. But he was delinquent on those payments, so there was a Portage County civil judgment against him. And in that civil judgment against him, Your Honor, he agreed, he signed this affidavit regarding his responsibility with CPACs, regarding his responsibility with doing CPAC sales taxes and financial records. And I, again, submit that this demonstrates his knowledge of his requirement to file and his control and his sole control and responsibility and knowledge that it was his sole responsibility to ensure these numbers were right. And not only that, you heard testimony from Agent Lieb that the defendant was on the habitual offenders list. He knew he was having issues. He willingly made those issues. He willingly kept bad records here so that he could financially benefit from them, to the tune of $203,000. Now, Your Honor, the Ohio Revised Code provides sentencing factors for this court to look into in order to properly sentence the defendant. As you know, the overriding purposes of felony sentencing are to protect the public from future crime by the offender and others, and to punish the offender. In looking at the factors that the crime is more serious, under 2929.12b, specifically the 4th factor, that the offender's occupation obliged him to prevent this offense and bring others committing it to justice. Well, again, I do agree with Ms. Hibbard that this portion of the indictment, this portion of the offense, didn't necessarily specifically relate to his job as the chief or an officer with the East Cleveland Police Department. He took a duty. Mr. Gardner took an oath to uphold the law. And here he has broken the very law that he swore to uphold, and he broke the very law that he has held others accountable for countless times. In looking at subsection D regarding the recidivism factors, Your Honor, there are multiple in favor that he is more likely to commit another offense. First, as I stated, he was on community control sanctions during this offense. He does have a criminal history as evidenced by his 2 previous offenses, which in defendant's sentencing memorandum, Ms. Hibbard did state that that was a long time ago. That was 2014. Well, Your Honor, while he was on probation in 2014, he gets on probation and he's already committing this crime. And that's as evidenced by the plea that we do have here to count 3 from January 1st, 2014 to December 31st, 2014. Your Honor, he also has shown that he has not responded favorably to previous sanctions. He's been given 2 different community control sanctions, and yet we are here today now with a felony plea. And I would submit at this time, there has not been a genuine show of remorse. I understand the defendant did accept a guilty plea. However, I don't equate a guilty plea necessarily with a genuine show of remorse. I'd ask this court to listen if the defendant does make a statement and then address it at that time. But just simply a guilty plea to the state of Ohio does not necessarily mean a show of genuine remorse and acceptance of responsibility. And I don't think that defense can say that this offense was committed under circumstances that are not likely to reoccur when you're looking at the factors of recidivism. Each and every time this defendant has been presented with an opportunity to commit a crime, Your Honor, he has done it. He has forged sales tax licenses, he has failed to file sales tax, and now when he's filing, he's failing to remit to the tune of $203,000. Now, defense did file a sentencing memorandum. There were letters attached to that sentencing memorandum. Based on the plea, I am not going to get into the substance of the other evidence that we did expect to present as to the other counts in regards to relation to Mr. Gardner's actual job as a police officer and control over the FOP. But we did expect to present a significant amount of evidence regarding that in this case. However, we did offer this plea agreement for fair, reasonable, and just resolution of this case. With that, Your Honor, I would submit that based on the facts of this case, based on the defendant's criminal history, and yes, based on the fact that he was a police officer who swore to uphold the law, he should be sentenced to a term of incarceration for his actions in this case. Thank you.
Before I turn to Ms. Hibbert, let me just indicate for the record, Ms. Stoll, I don't question the plea agreement. I presided over the trial. I was certainly present while it was great discussion about possible resolutions. So I appreciate your willingness to resist temptation to go into other areas. Ultimately, I want to make certain that we're clear that the focus of my sentencing will be on the facts that give rise to the plea that he entered, to that single count. So with that having been said, I'll turn to you, Ms. Hibbert, to give you an opportunity to make statements on behalf of your client.
Thank you, Your Honor. Would you like us at the podium or to remain here at the table?
Wherever you're more comfortable.
Thank you, Your Honor. Your Honor, Mr. Gardner did enter a plea of guilty to this 4th-degree felony, and he absolutely does accept responsibility for underreporting that sales tax number and not paying enough to the state of Ohio. When Mr. Gardner learned of his shortcomings in that regard, he took immediate action to reach out to the prosecutor's office, to the Ohio Department of Taxation, to a tax attorney, all within just a couple months, maybe even a month, quickly, very quickly, Your Honor, to correct what he had been doing to pay back the money that he had kept for himself. And he did financially benefit from the mistakes that he made. He was reckless. That is the standard that we are operating under, Your Honor. Mr. Gardner acknowledges all of those things, and he's prepared to tell you that himself. He ran a successful security business, and they were making a lot of money, and the figure looks extremely high, and it is an extremely high figure. It did occur over the span of 6 years. Mr. Gardner is sorry for what happened. He absolutely is remorseful. This has been very, very difficult for him. He has asked me on a number of occasions, what am I gonna do? I have to make sure that this never happens again. Like it worries him. He doesn't want to engage in this sort of behavior. He doesn't want to be seen as somebody who would steal from the state of Ohio. Mr. Gardner is a person that cares about others. I can say that from my personal experiences with him. I can say that from the way I see him interact with others. He is a very kind man. He is generous. He would help anybody with anything. He really would. It's just his nature. I know I had said it before, but just as generous as Mr. Gardner is with others, he would pay for things for others. You saw that in the letters. He would buy other people things if they needed them. He put his own money into the department. He put his own money into the FOP. And maybe some of the money was that. But Mr. Gardner is, not only did he do those things, but he is trying to pay that back. And he's paid a significant portion of that back. And he will continue to make payments on that. He's dedicated to doing that. He's dedicated to taking care of his responsibilities. And he cares about other people. Him attempting to be a cheat or a thief or anything of that nature is not his intentions. It's really not. Mr. Gardner is a caring person, and I think that he is going to now tell you how he got into this situation, and he would like to apologize to the court and the state of Ohio.
Your Honor, thank you. Yeah, it's been 2 years since I've been able to talk about this, and I greatly do apologize. I apologize first off for wasting the court's time, wasting the state of Ohio's time. It was never my intention to have this underreported, and as Ms. Hibbert expressed, as soon as I found out what was happening, and the state makes the allegation of why I did it after the subpoena. Well, I didn't know there was anything wrong or going on until I received the subpoena. I immediately took action. I fully acknowledged that money is not my money. The money was accepted, as I've learned, that I should not have accepted or kept. So I fully acknowledge that, and I fully prepare. Since that time, I've had certified public accountants filing my sales tax with the interim of my CPA actually firing me because of this incident recently. But my intention is to make certain that this does not occur again. This is not who I am. This is not what I want my perception to be for the remaining time. And I appreciate the time, Your Honor, for me to be able to speak.
I want to be real clear, Mr. Gardner, because I don't want you to have any false impression about the impression that you've made on me. This isn't just reckless on your part. I don't believe that for 1 minute. Not for 1 second do I believe that you're just a poor bookkeeper. We're talking about a factor of over 10. You paid $1,000 when you were supposed to pay $12,000. You paid $3,000 when you were supposed to pay $49,000. That's not an oops. That's not I just am a sloppy bookkeeper. That's a person who essentially was, and maybe Ms. Hibbert is right when she says that you did good things with some of that money, but you were essentially robbing from Peter to pay Paul. And I don't buy the argument that it was just an oversight. And as soon as it was brought to your attention, you said, oh my gosh, let me correct this. I believe you believe that you could just do this, get away with it, nobody would notice. But for the phenomenal investigative work done by the agents who testified in this case, I think you never would have paid this money. So I don't buy that argument. I don't buy the sloppy bookkeeper argument. It doesn't fly. I'd listen to the testimony. Sometimes when cases aren't tried, as judges, it becomes difficult to assess what really happened because you don't get to really hear the facts of the case as much as you do when there's a trial. But here, it was abundantly clear that you just were kind of running a scam. I mean, we're not going to get too deep into it because a lot of the counts were dismissed against you. But there was an awful lot of testimony that I heard that signaled a guy who was willing to cut corners. That's who you are. I mean, let's not kid ourselves, right? This is your third time in a courtroom, or is it fourth? Third or fourth time?
Third, Your Honor.
All right, so we have two separate instances where you've been charged with this sort of behavior, right? The first time it happens, you might say, oh my gosh, whew, here I am, a police officer, I've been charged in Portage County for misconduct revolving around a cigar shop I own. You might say, well, you know, I'm a fine police officer, but I'm a bad cigar shop owner, operator. I've got to do better. Then you get another case and you say, oh my God, I can't believe this happened again. I've got to do better. Now a third time and we're supposed to write that off as just another oops. That's nonsense. I don't buy it, not for 1 minute. That's not to suggest that Ms. Hibbert is wrong when she says that there's good in you. I'm certain that it's true. But you were stealing. To come in here and say something else is somewhat offensive. In the end, though, what you pled guilty to was a single fourth-degree felony with a presumption in favor of community control. And as judges, we're not just throwing darts at a spinning board and hoping that we hit the right sentence. We use the guidance that we're given. And this is a non-violent offense. You have no felony criminal history. So this is your first felony conviction. I don't see that as a small matter. I see, particularly someone who's spent their career in law enforcement, having to carry around a felony conviction as a significant thing. So although I'm in no way fooled by your story of the hapless business owner who just can't shoot straight, I'm not going to overreact and incarcerate you today. I don't believe that police officers, when they commit crimes that are really unrelated to their business, ought to be treated more harshly than, say, a butcher, a baker, or a candlestick maker. You know, the fact of the matter is, I'm going to sentence you like I would anyone else charged with a low-level, non-violent felony of the fourth degree who has no prior felony criminal history. So, although I certainly appreciate why the government might be inclined to ask for prison here, I think it would be an overreaction. I think it's unfair to people who have committed their lives to law enforcement, which is a real honor to be able to say that my job is to protect and serve the community. I mean, that's a real honor. But I don't think that the payback for having committed yourself to a life in law enforcement is for judges to immediately send you to prison and apply some sort of police officer specification. That means whenever a police officer commits a crime, they have to go to prison when another person wouldn't. I don't think that's appropriate. So I'm not going to incarcerate you even in the face of your foolish explanation as to why you did this. You need to take some time while you're on probation and do some soul searching and figure out what your life plan is going to be. Because cutting corners and running raggedy businesses where you steal from the state hasn't worked for you. You're now a convicted felon. Here's where it gets a little bit more interesting. Now that you are a convicted felon and you're about to be on probation to me for the next 5 years, if I even get a whiff, a sniff, that you're cutting corners out there in the world, that you're running some kind of a business and maybe not doing the things that you're supposed to do, that maybe you've put a business in someone else's name and you're teaching them how to cut these corners, if I find out about it, you're going to prison. Do you understand me?
Yes, Your Honor.
Is there anything unclear about that?
No, Your Honor.
You're going to have to pay this restitution. You will be responsible for, what's it, $149,000? $149,954.50. That restitution will be a condition of your community control. If I sent you to prison, it would make it more difficult for you to repay that debt. So that's one of the other benefits of you being able to be in the community. And in addition to that, it's also not lost on me that you tarnish the badge when you do this. Now, you didn't do it relative to your work as a police officer, right? This wasn't something that you used your role as a police officer to sort of get away with the crime. But look, let's be clear. The reason why all these cameras are pointed at you is because you're a police officer, not just a police officer, but chief of police who has fallen this far. It stains the badge. It blemishes the badge. You're going to have a consequence that's tangible, not just the intangible consequence of a felony conviction. You're going to give back to the community. This went on for many years. Going back to 2014, our window is a 6-year window. So with that in mind, you're going to do 600 hours of community service. 100 hours for every year that you engaged in this scam. And that's what it was. It was a scam. I don't be repetitive, but the sloppy bookkeeper story is not believable for a guy that's been in court on 2 separate occasions for similar conduct. So for each year you engaged in this scam, you'll do 100 hours of community service. I would certainly, I would never, over any point in that 5 years you're on probation to me, I'd never forget that I'm giving you a chance, that your judge gave you a chance, right? But that's all it is. If it turns out that Ms. Soul and the state of Ohio is right, and you just don't have it in you to do good, then you'll make a mistake over these 5 years, and you'll end up going to prison. On the other hand, I hope that just like me, on some level, the state of Ohio is rooting for you to do well, right? The goal of this is to see people not recidivize. The goal of this is to correct behavior. And there ought to be punishment. The punishment is the 600 hours of community service. But the hope is that over the course of the next 5 years, even if it's only out of fear, the state of Ohio won't have to worry about you stealing from the state anymore because of that heightened anxiety that your freedom is at stake. Do you understand?
Yes, sir.
Normally, it's the court's inclination to create incentives for people to do well on community control, and so I always look for ways to consider terminating community control early. So I would commonly put people on maybe 5 years of community control, but I'll say, look, if you can show me a year of sobriety, 12 straight months, we'll terminate your probation. But I want you to understand, I'm not going to do that in this case. I want there to be some certainty that you're being supervised for as long a period of time as I possibly can. So that's the maybe the one dissimilarity to the way I'm treating you and I might someone else. I want you to be supervised for as long as the law allows me to do it, and that's the 5 years. So while you're on community control, you'll report monthly. You'll be drug tested. You will have to maintain verifiable employment. You are on a habitual offenders list, so you can't operate a business in the state of Ohio. You'll have to have some sort of verifiable employment. I'll give you some flexibility there because I understand that you are retired, but there's going to have to be some work. You'll have to show that you're doing some work in addition to just the community service. As I indicated, you will be drug tested. I don't know if there's a drug issue here. Maybe there's not.
None whatsoever, Your Honor.
That's fine. I'm happy to hear that. But on the off chance that there should come a time where you test positive for an illegal substance, I want you to understand, I'm not going to incarcerate you for that. We'll talk more, and we'll figure out a way to help you if there is a drug issue that should arise. And to that end, I want you to be forthcoming with our probation department. If there are issues that you have that maybe haven't been addressed in open court, maybe they're too private to discuss in open court, discuss them with your probation officer. Develop a relationship with the probation officer so that you can speak with that person. We have a fantastic probation department. Bless you. I certainly hope that you're able to pay this money back. I don't want you to think that just because maybe on some level I've had some harsh words for you, Mr. Gardner, that I want to see you do poorly. To the contrary, my hope is that this sentence will have the net effect of you doing well and extricating yourself from the system and never having to go through this again. Do you understand?
Yes, Your Honor.
Ms. Sowell, anything else on behalf of the state?
No, Your Honor, we would just ask the journal entry to reflect the restitution amount.
It will be in the journal entry.
Thank you.
Ms. Hibbert?
Nothing, thank you, Your Honor.
We're adjourned.
All rise.
Oh, I think it's-
Thank you.